Hi, this is Curt and welcome to another edition of Fire Law Roundup.
We've talked about this one before, and now we have the resolution. We think the full resolution. We're going to go to Harris County in Texas, where a jury just awarded a former firefighter $250,000 over a nude video. As I'll kind of summarize the facts, but somebody clearly, it seems, went into this former firefighter, Melinda Abt, ABBT, I'm not sure how to pronounce that, but went into her computer while it was at the station, somehow found a video of her, a nude video that she created for her husband, and then gave it. It started circulating amongst the leadership who would come into the captain's or chief's office and watch it. And so she complains, obviously, and about the captain's conduct. That captain, I think, gets promoted.
No, he got demoted too.
Or demoted, but I thought after
he went busted down a firefighter. I'm assuming.
Right. Yeah. And in any event, so the captain's watching it, a district chief is watching this video, right? Another firefighter was brought in to watch it. She found out about it years later, I think, or later.
Yeah, it was years later. And it's actually, I think the district chief ended up telling her husband about it. And then that's
right. And her husband's also a firefighter in the same department.
Right. Well, they both have since left the department, yes. Which I don't blame them.
Yep. You know. And the captain was, as you said, was suspended and demoted. So there's a $250,000 jury verdict as against the captain. We're not really sure what happened as against the city, though.
Yeah, I'm not sure. And one of the problems with trying to read a journalist's understanding of what happened is difficult. And I actually went to a law firm's website, and all they did was they basically parroted back what the newspaper had said. So, but it looks like from what the news has said is that the verdict was against the captain and not against the city. So, and the fact that there was a punitive award, usually that you don't get punitive awards against municipalities. So I think that's it. But, this is not an isolated case. And I think it's, fire departments are going to be confronted with this more and more as, people are more liberal with some of their activities.
Liberal is a nice word.
Yeah, well, we saw a similar phenomenon, a little different, but a similar problem in Las Vegas not that long ago. And fire departments have got to think about this, and unions have got to think about this, because the union finds itself in a real bind in these situations because they represent the victim. They also represent the perpetrator or perpetrators. And they can find themselves in the Las Vegas case. The woman had a very, very sharp attorney, and she did what probably you and I would do. They sent an evidence preservation request to everybody involved, and that included the leadership of the fire department, the leadership of the union, and then all of the members at the stations where it was going on. And now that evidence preservation request may not seem like a big deal to the average firefighter, but you and I realize the consequences of that. If you now lose your cell phone or delete pictures or delete text messages relating to it, or even if you're forwarding the video, any sort of deletion of that could be a criminal offense, but it could certainly come back to haunt you in the event that there is a civil suit and you're dragged into it. So there's a lot to think about here. And I often think about, how do you advise a client to preserve all of the evidence that may be out there when you get one of these evidence preservation requests. There are services, and Brad, you're much more up on it than I am, but there are services out there that can basically copy, make a mirror image of your laptop or your network or even your phone, so that it kind of gets you off the hook on the spoliation end. But then, if the fire department tells 200 firefighters, you have to turn over your cell phone so we can mirror image it.
Right. Right.
You're going
And
to have
look,
a problem.
lawyers,
You're going to have a problem there.
all right, and lawyers can get disbarred for not relaying the order, the attorney's notice to preserve the electronic information, and we'll find out. I think I was telling you, because we talked about this, in another episode a month or so ago, and I said, I have an issue where I'm pretty sure someone intentionally deleted a video, and I've now subpoenaed the software for that video to show whether I can see on the logs who deleted it. And if I do, and it was after this lawsuit started, you can bet it's going to be brought up by me in court. So attorneys should be very careful about this. Attorneys don't ever want to advise anyone to, hey, you might want to delete that now, right? It's one thing telling someone, look, and I do want to say this. If somebody has something on Facebook, right, and it's open for everybody to see, and it's harassing or whatever it is, the issue in the lawsuit, you can remove it from everybody's view, right? You can change the view setting to stop the harm, and that's an acceptable response. But you can't just delete it and say, "Oh, I don't have the video anymore because I removed it." You just can't do that. But everybody should be fearful that every electronic device, whether it's a laptop or a camera or their phone, can be used against them and can be seized and reviewed by a court. So going back to this one, look, I mean, this is harassment, bullying, sexual harassment, but, and I don't mean to demean the leadership, but come on, how sick, right? I mean, it's a coworker, and, the jury, look, the jury found what they found. So this isn't where we normally say allegedly. The jury found guilt here, right? So here, what the jury found is the chief and the captain are watching this repeatedly, like over time. Come on. Right. And if everyone knows, well, why isn't the city liable? The city should be liable. Even though this may have been an intentional act, it was an act done by its supervisors. So the city shouldn't. I can't imagine they're going to escape liability here. I just
there was nothing in the media. I didn't go back and look on Pacer or on Lexus to see
maybe they separated
the status of the case. But the sexual harassment case, originally the entire case, assuming it was filed as one case, I believe it was filed as one case in Harris County District Court, and then removed on the sexual harassment allegations, the Title VII allegations, which is a federal claim that was removed to federal court. And then they have pendant jurisdiction over the state claim. So the federal court, the district court basically dismissed the federal claims. And then that was appealed up to the Fifth Circuit. The Fifth Circuit reversed and said, no, she's got a right to a day in court. Now, how it got from that point back to Harris County, I'm not sure, but that would appear the state claims were proceeding
maybe
against
they severed them. Who knows? The more interesting legal issues that no one listening will find interesting.
There you go. Absolutely.
This is what going to dinner with Curt and Brad is like. You'll be bored to death, but smile. Okay.
Well, a couple of bottles of wine and cider. And